This hearing was supposed to be simple: a probation violation review, a sober monitoring device, some test results, maybe a misunderstanding. Instead, it turns into a full-blown credibility showdown between a judge who has seen everything and a defendant who swears she hasn't had a drink since December. Here's what we're dealing with. Miss Greyhouse is on bond with conditions, one of them being no alcohol. She's ordered to use a Soberlink device, which measures breath alcohol remotely. Within days of getting the device, it starts reporting positives. Not one, not two, a pattern. Multiple readings over multiple days. Now, in alcohol monitoring, numbers matter. There's a cutoff threshold. Below 0.020% may not require reblowing. Above it, the device keeps demanding new samples. That's designed to rule out toothpaste excuses, mouthwash defenses, and environmental contamination. The probation director says the readings are consistent with drinking. The monitoring company rep says he initially thought maybe malfunction, but after doing the math on elimination rates, consistent with consumption. The defendant says it's brushing teeth, cigarettes, stress, device glitches, and the judge, he's listening, but he's not buying it. What makes this explosive isn't just the test results. It's what happens when the judge starts talking about perjury, jail, bond forfeiture, and the possibility that this could have been charged as a felony. This isn't just about a breath test anymore. It's about truth, credibility, and whether this courtroom believes her. Let's break it down.
Decide things over a bowl of Cheerios. I knew if we had a hearing today, you were going to at least have this, because I was sure you were drinking. Raise your right hand, please. Do you solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God?
I do.
Okay.
Sure. On February 5th, Ms. Greyhouse was referred to house arrest services to obtain her Soberlink device, which she did do in a timely fashion. I was notified on February 8th that Ms. Greyhouse was positive for alcohol.
Right away, we see something important. The first reading is 0.019%, just under the 0.020 cutoff that requires a reblow. That detail matters because it shows how precise this system is. It's not reacting wildly to tiny traces. There's a threshold built in. But here's what's interesting. The judge interrupts almost immediately to clarify who's testifying and how this information is being presented. That tells you he's already focused on procedure and reliability. And then we move into February 9th, where the numbers jump. 0.029%, 0.023%, 0.020%, 0.025%. This isn't a single stray reading. It's a pattern. When courts evaluate alcohol monitoring, they don't look at one isolated number. They look at trends over time, repeated positives across multiple hours and days. That becomes harder to dismiss as mouthwash. So the real question forming here is this environmental contamination, or is this consistent elimination from drinking? Because that distinction will decide everything.
At 7:27 p.m. with a 0.019%.
Wait 1 second. He just told me house arrest is out there. We'll bring him. All right. House arrest services. You can start your video, unmute, and state your name, please. There you go. Thank you. Your name?
Yes. Hi, my name is James Hunt.
Okay. The probation director is just beginning her testimony, so we're going to let her conclude, and then we'll go from there. Thank you. Go ahead.
Yes, Your Honor. So again, just briefly, February 5th, Ms. Greyhouse was ordered to obtain the Soberlink, which she did. I received an email February 8th indicating that Ms. Greyhouse was positive for alcohol, 7:27 p.m. at 0.019%. For counsel and for yourself, Judge, anything below a 0.020% does not require a reblow, and therefore no reblow was required at that time. On the 9th, as listed on the sheet that counsel has been provided, as well as yourself, Your Honor, Mr. Hunt does have this information as well. Beginning at 11 a.m., Ms. Greyhouse was positive at a 0.029%. She called house arrest services claiming this was due to brushing her teeth. House arrest services did inform her to continue to blow as required. So at 11:17, she was and this is a typo on my part, that was 0.023% at 11:17 a.m., Your Honor, again, my typo. At 11:34 a.m., she was 0.23, 11:53 a.m., 0.017, again, under that cutoff, no more reblows were required, but resumed to be positive at 3:26 p.m. at 0.020, 344 at 0.013. Under that cutoff, no further blows required. Continued to be positive that day. 7:22 p.m. at 0.023%, 7:40 at 0.022, 7:57 at 0.019 under the cutoff. Continued to be positive that day at 11:22 p.m. at 0.025% and 11:39 p.m. at 0.018% under that cutoff. Then on the next day, February 10th, she was negative for her morning blow. However, resumed being positive at 11:27 a.m. at 0.023, 11:44, 0.017% under that cutoff. Continued to be positive that day, 3:27 p.m. at 0.040%, at 3:44, 0.033%, at 4:02 p.m. 0.027%, 4:19 p.m. 0.021%, at 4:37 p.m. 0.016 under that cutoff. She did continue to be positive for alcohol, however, again, under the cutoff at 7:29 p.m. and 11:18 p.m. The following day, February 11th, she was negative for her morning blow. Positive again, 11:25 a.m. at 0.025%, 11:43 a.m. at 0.021, and at 12:02 p.m. under that cutoff at 0.016. She continued to be positive under that cutoff at 7:11 p.m. at 0.019%, and at 11 p.m. she did fail to blow. An hour and 55 minutes later at 12:55 a.m. she did blow, and she was all zeros on her late blow from 11 p.m. Last night. In the meantime, she did call house arrest services, and she claimed that her device was malfunctioning because it was requiring her to continue to blow. House arrest services did inform her that as long as it told her to reblow, that she needed to. This is what happens when we're positive for alcohol. It's going to have you blow until you are under that cutoff to ensure that it isn't environmentals like toothpaste and all the other excuses that sometimes we hear. But the one excuse that Miss Greyhouse used about brushing her teeth back on February 9th. I did ask them to send over her contract as well that she signs with them that indicates that she agrees to wait at least 20 minutes after using any mouthwash or any product containing alcohol, such as, but not limited to, hand sanitizer or any other topical substances that may include alcohol like cologne, perfume, bug spray, before she submits a test, as well as she agreed to submit to required tests if requested by the device after a sample had been submitted. There is no issue with Ms. Greyhouse continuing to blow, but again, it's not a malfunction of the device. Mr. Hunt here is to do his testimony. It's because of the detected use of alcohol.
Notice how the probation director explains the purpose of repeated blows. When someone tests positive, the device forces additional samples to see if levels are rising or falling. Rising levels, that suggests ongoing absorption. Falling levels, that suggests elimination after drinking. That's not random, that's science. And she also mentions the contract Miss Greyhouse signed, agreeing to wait 20 minutes after brushing teeth or using alcohol-containing products. That's critical, because once you sign those conditions, doesn't carry much legal weight. Courts rely heavily on these signed acknowledgments. They establish that the defendant understood the rules. So now the toothpaste explanation has to overcome both the pattern of readings and the signed agreement. That's a steep hill.
That she had to continue to blow, Your Honor.
Okay, do you have any questions of Ms. Wiles?
Do I?
No, you're a lawyer.
Ma'am, you're not technically prepared to testify.
Please, that's.
Reliable as device, correct?
I would leave that up to Mr. Hunt, sir.
So the answer is no. You're not.
Christopher Cruz.
Okay. Mr. Hunt, I'm going to ask you to raise your right hand, please. You solemnly swear or affirm the testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
Do you want to ask him some questions?
I'm going to ask him just a brief question in relation to an email, and then I'm happy with Mr. Longton, of course, to ask Mr. Hunt any questions. Mr. Hunt, you and I had talked on the phone. I asked you to review those blows from Mrs. Greyhouse in reference to the possibility of that device being defective. and you indicated to me that as a knee-jerk reaction, you did feel that it could be a malfunction of the device, but that you wanted time to look at those blows and make, of course, a more professional decision. And you indicated to me in the email, I'm going to ask you if this is correct, that in looking at each single event, these are consistent with drinking.
This is the turning point in expert testimony. The monitoring representative admits his knee-jerk reaction was device malfunction. That actually helps credibility because it shows he considered alternatives. But then he says he did the math on elimination rates, and the results are consistent with alcohol consumption. That's a powerful phrase. Elimination rates refer to how alcohol leaves the body over time. If the numbers decline in a predictable biological pattern, that supports drinking. If they spike randomly, that might suggest error. Here, he's saying the math aligns with drinking. And that's not opinion, that's pattern analysis. So now the defense shifts strategy. Instead of arguing she didn't drink, they begin probing whether the device itself could fail. Smart move, but it's about to get complicated.
Is that correct?
That is correct, yes.
Thank you. No other questions, Your Honor.
All right. Do you have any questions of him?
Mr. Hunt, when my client calls Soberlink to complain about the device, did she talk to you or to someone else?
She would have spoke to somebody in the monitoring center.
Who would she have spoken?
I would have to pull some calls to get names. I do have a note in here from Miss Hall, one of our monitoring room employees.
And that note says what?
That she called and stated the device keeps telling her to take to test multiple times. We advise her to just keep testing when the device says to. She stated that it may be because she smokes cigarettes. We advised her to reach out to her officer if she has any questions about the report.
What else do you have in your notes?
I have another note in here from a Miss May that says that the client called and stated she brushed her teeth and then left the house and tested on her device.
Do you have any other?
Those are the two notes on her account.
Do you have any notes from your staff indicating that they spoke to her about having the device recalibrated?
I do not know.
How often do these devices need to be recalibrated?
The devices are recalibrated after 1,500 tests have been taken. This device, I'm still waiting to hear back from the manufacturer because this was kind of short notice. But this device has, as of right now, 1,448 tests remaining until calibration, which indicates to me that the device was recently calibrated before given to Miss Greyhouse.
Isn't it true that these devices sometimes fail before reading 1,500 tests?
It's technology, so yes, that's certainly possible.
Isn't it true that it has happened and you have a record of these devices failing?
Yes.
So you don't know whether these test results are accurate or not.
But I mean,
You don't.
no, I do not. No.
Now we enter technical doubt territory. Defense counsel presses the monitoring rep. Can devices fail? Yes. Has it happened before 1,500 tests? Yes. Is it technology? Yes. That line of questioning plants seeds of reasonable doubt. But notice what's missing. Actual evidence that this device failed. The machine had 1,448 tests remaining before recalibration. That suggests it had just been serviced recently, and there's no calibration report showing malfunction. So legally, the defense has theoretical doubt, not documented defect. In court, possibility isn't enough. You need probability backed by evidence. And right now, the only documented pattern in front of the judge shows repeated positives consistent with drinking.
Got nothing further to say.
Do you have any other questions?
Nothing further, Your Honor. Mr. Hunt, is it possible to send a device into the manufacturer to determine in this circumstance if this is a device failure or not? Would there be a definitive answer?
Yes, absolutely.
Thank you.
Well, Mr. Hunt, the question is, if you send it back to the manufacturer, can they tell definitively whether or not it has been failed? Are you technically an expert that you could tell us if that's true or false? Does the manufacturer tell us definitively whether or not it's been failing?
I would be able to recite the report that was given, but no, I'm not an expert in device calibration. No.
So we don't know whether or not the manufacturer's report would be definitive or not, do we?
We don't even have that report yet to determine if it's definitive.
I'm sorry, guys, this is just totally cross it down.
Wait a minute. I want to interject.
That I wasn't done.
Yeah, let her finish first. Go ahead. You want to ask a question?
Yeah, I had a follow-up question to that, but
go ahead.
Mr. Longton chimed in. Mr. Hunt, and it actually alluded to what Mr. Longton was. So if we send that device in and the manufacturer reviews the device and we get that report back, that then, piggybacking off Mr. Longton's question, then being the expert, because that is their device, would we know if it malfunctioned or not?
Yes, correct.
Thank you. And I am done now.
And read the conclusion that he drew in the email again. Will you do that for me, please?
I can actually read that in whole. It says, good morning, Ms. Wilds. As we discussed on the phone, I went ahead and did some math to figure elimination rates. And these events are consistent with consumption. I have a consolidated report attached, and I also have a detailed report covering her positive dates from 2/9 to today. Knee-jerk reaction, seeing the mix of positive and compliant, was device failure, but looking at each as a single event, these are consistent with drinking. If you have any questions, please let me know. And it is signed by Mr. Hunt.
All right. Do you have other questions?
I have none. I have my confidence, that's it.
Okay. Raise your right hand, ma'am. Solemnly swear affirm under penalties of perjury the testimony you give in these proceedings will be the whole true self you got. Okay, go ahead.
So what happened during the earliest possible?
I'm sorry, I didn't hear the question.
What happened with Soberlink starting with these early possible days like February? What happened?
On the night, so I had taken a couple of days off since the last time I was in court and I stayed home. And then I went back to work that Tuesday, I believe, and I'm in my car a lot. So when I left this morning,
Wait a minute. Which morning are you talking about?
the 9th,
It was at this moment that she knew. She fucked up.
I believe that was Tuesday.
Well, the first one said she was positive for alcohol at 7:27 p.m. on February 8th.
Talk about February.
8th. What day of the week was that?
February 8th would have been a Sunday.
Honestly, Sunday I was at home with my kids. We played some games, had the football game on. I got them to bed because I had school the next day. And then, so it must have been Monday then.
February 8th is the thing.
Okay, so then starting that Monday, I had gone back to work, back into the office, driving around throughout the
So the
day.
question is, what happened on February 8th at 7:27 p.m.?
No idea. You know, I didn't ask, I don't remember that it asked me to retest. Honestly, that was on Sunday. I don't remember.
Go ahead. On the 9th, you went to work. What time did you go to work?
I left my house at about 10:45.
Okay. Where do you work at?
The office is in Allen Park, but I drive clients around or meet them at different houses. I do real estate.
Okay. So
So on Monday, I had a client that, well, I went to the office first. We had an 11 o'clock Zoom. I did the Zoom and then I left. I met up with the client, so I did a bit of driving around. When I had gotten the first one, I brushed my teeth, left the house. I do smoke cigarettes, so when I called, I didn't claim that it was because of brushing my teeth. From my recollection, that was the first time it had asked me to retest. So when it happened, I called right away and asked about it. I called house arrest. And I said, this is asking me to retest. And so I had asked questions the day when I signed the paperwork, when I got the device, and like Ms. Wilds had explained, like they did kind of go over everything. That was the day that I was in court. necessarily remember the 15 minutes before and all of that stuff. No, yes, I did sign it. There was a lot going on. It was high stress, high anxiety. She went over it.
Let's keep.
Okay, so this day, all day I was driving around clients and I picked my kids up at this 3:26 time. I was with my kids. We went home, we had dinner. That was on Monday. They didn't have any sports that evening.
When is the last time you consumed heavy alcohol? Is it before February 8th, 26?
It was. Yes, it was in December.
Last time you consumed alcohol?
Yes, sir.
Did you consume alcohol on February 9th any time?
Here it is. Direct question. Direct denial. No, sir. This is the moment everything hinges on. Because once she denies under oath, the stakes rise dramatically. If she's lying, it's perjury. If she's telling the truth, then the device is wrong. And the judge begins dissecting the timeline carefully. No positives on the 5th. No positives on the 6th. No positives on the 7th. First positive appears on the 8th in the evening. That's important, because it suggests the device functioned properly for several days before producing positives. If it were defective from the start, you'd expect erratic readings immediately. Instead, we see a clean run, then a shift. That pattern does not favor the malfunction theory.
No, sir.
So, on your device, when you blew at 326 and 344, did you see these readings on your device?
No, sir.
You don't see these readings?
No, sir.
They don't. And we're, okay, so you just
So I
said
did a
it.
retest. No, sir.
And when you're asked to reblow,
Yes, sir.
when were you asked to reblow?
Tells you to wait 15 minutes.
Right, so on February 9th, how many times were you asked to reblow?
The 9th. Felt like every time I did it, that's why I called. And then I wasn't asked to reblow on the 10th in the morning. and I
Let's stick
think
with the 9th.
Okay. So every time, and I had called that day and I called house arrest. And I said, it keeps asking me to reblow. What could the reason be? She said I could bring it in and have it recalibrated. And then I had.
Did you, okay, go ahead. I'm sorry.
So then the next test, I believe, did not ask me to reblow. And then the one in the evening, I think did ask me to reblow. And then the next day, it didn't in the morning. And then it did a couple of times throughout the day. I think that one was the day that it asked me multiple times, or maybe not.
Let me ask you a question.
Yes, sir.
I ordered you to go and get the Soberlink the day you were in court. That's February 5th, right?
Yes, sir.
Did you go on the 5th?
Yes, sir.
Did you have any problems when you blew into the machine on the 5th after you acquired it?
The first machine they gave me was not working, so she gave me a second one, and then
Before you left?
no.
Wait a minute, slow down. Let's slow down. You went over to house arrest on the 5th
Yes, sir.
in Livonia.
Warren.
Warren, I'm sorry. Warren,
Yes, sir.
you said she replaced the machine?
The first one she gave me was not working.
And did she replace the machine before you left house arrest?
Yes, sir.
Okay, so you went back from house arrest on the 5th, right? With a workable machine, at least in your mind.
Yes, sir.
Did you have any problem when you blew in that machine on the 5th?
No.
Did you have any problem when you blew in that machine on the 6th?
On this, I don't remember if it was.
Well, let's wait. Let's not guess. The 8th was Sunday.
Yes, sir.
The 5th would have been Thursday.
Yes, sir.
You got the machine on the 3rd, on Thursday, the 5th.
Yes, sir.
You didn't have any positive blows with it on the 6th, right? You didn't have any positive blows with it on the 7th. Wait, let me finish. You didn't have any positive blows on that machine on the 7th, did you?
No, sir.
And when you woke up in the morning, when is the first time you tested on the 8th?
Would have been between 6:45 and 7.
Did you have any positive blow on that time, on that occasion? Well, any problem with the machine testing inappropriately until at least 11 o'clock on or about the 9th of February?
It was the 8th.
Okay, you're right.
The only issue.
Wait a minute, slow down, my mistake. On the 8th, you blew positive at 7:27 PM, right?
Yes,
How many times did you test it on the 8th prior to the 7:27 positive blow?
I tested 3 times.
Any problems with those results when you blew on the 8th prior to the 7:27
Was there-
blow? Any problem with the machine when you blew on the 7th?
Not with a retest. The only issue I had with the machine that Saturday was that it wasn't turning on. And when it finally did power on, it had battery. So it wasn't that the battery was dead. That was kind of when it's. I didn't think much of it.
Any positive blow on the 7th? I'm asking you.
Oh, no.
Any positive blow on the 6th? Okay. Anybody have any other questions on it? Go ahead.
Your testimony been completely candid?
You got to keep your voice up for me, though.
Up,
Yes.
When you heard, has your testimony been completely candid?
yes, sir.
Last time you had a drink was in December.
Yes, sir.
You willing to take the polygraph?
Yeah, we.
They're much more reliable than they were when you and I started practice law. And the Taylor Police Department has a polygraph, and they're more than happy to pay for the polygraph. Because otherwise, you're going to make a decision based on a device that could well be defective.
It could be, and if I am not satisfied by a preponderance of the evidence that she consumed alcohol, I'm going to find her not guilty. No, wait, just wait. Let's not. I don't want to talk about polygraphs. You ask your next question. Mr. Hunt, I want to ask you one while he's thinking.
Yes, Your Honor.
I want to make sure I understand. You said maybe every 1,500 blows it has to be recalibrated. Right?
After 1,500 blows, yes, it's due for
You
recalibration.
said this particular machine, based on your inspection, still had roughly, I think you said, I want to double check, 1,444 blows left.
1448.
1,448 blows until the machine needed to be recalibrated.
Correct, yes.
Go ahead.
Mr. Hunt,
Yes.
last year in 2025, were there machines that turned out to be defective before there were 1,500 blows?
I'm sorry, can you say that again?
Last year, January through December of 2025, were there devices that turned out to be defective and needed calibration before 1,500 blows?
Yeah, it's technology. Things can fail. That's absolutely true.
And you had devices that did fit, correct?
Yes.
I don't think there's any question in my mind but that she was drinking. Okay? I get this all the time. And there's no question in my mind that she was drinking.
And now the judge says it plainly. There's no question in my mind that she was drinking. That's a credibility finding. Judges are trained to assess demeanor, consistency, body language, and testimony structure. He's not just looking at numbers, he's evaluating how she answers. Then comes the escalation, polygraph discussion. He even says if she fails, he'll put her in jail and set a bond she can't make. That's serious. When a judge talks about perjury and incarceration in the same breath, it means he believes the false statement happened inside his courtroom. And judges take that personally.
And I'm not going to order a polygraph. I'm not sure I don't want to send her for a test. But I'll tell you what, I'll send her for a test.
If she flunks, put her in jail. Because I'm confident she's not drinking.
If she flunks on this test, I will put her in jail and she will remain in jail. I will set a bond she won't be able to set because I've just then, in my view, as I believe now, have had somebody commit perjury in this courthouse, and I don't think very kindly of that. So yes, let's have her go to on-site today.
Yes.
Now, I am not going to be here tomorrow but I will be more than willing to Zoom tomorrow. And we can Zoom on this case at 9:30 in the morning or 10 o'clock in the morning. You available, Mr. Longton?
I will change my schedule.
Yeah, let's do that. I'll do that. We'll continue the hearing at 10 o'clock. Now, I'm going to give you one last opportunity.
Yes.
I'm going to let you go test. If that test comes back positive, as opposed to me finding you guilty right now, I'm going to set a bond you will not be able to make. Do we understand? Maybe you need to go confer with your lawyer. I've been doing this a long time, young lady. I can tell who's telling me the truth or not. I don't pretend to have every answer, but I'll tell you what, I'll compare my ability to determine somebody's credibility with anybody's. And I don't believe for 1/2 a second that you're telling me the truth.
This is raw judicial frustration. The judge says he doesn't believe her, for 1/2 a second. That's not subtle. He gives her one last opportunity. Consult your lawyer before we send you to on-site testing. Because if that test confirms alcohol, the consequences escalate dramatically. Notice what he's doing, offering procedural fairness while making his view clear. He's not rushing judgment. He's giving her a chance to rethink her position. That's important legally, but it also signals that in his mind, credibility has already collapsed.
And then if you go and test and I have confirmation that you've committed perjury in here, we're going to have a massive problem with me. It's going to be so big of a problem, you're not going to want to, you're not going to believe how bad it's going to be. So I think before I send you for that test at on-site, you need to go confer with your lawyer for a few minutes. And after you confer with your lawyer for a few minutes, if you two want me to still order you to go to on-site, I'll order you to go to on-site. But do this, listen, don't talk to him now in front of me. Go take a few minutes. But think very carefully about what you're about to get into, okay? Do we fully understand one another? Okay, all right. You guys go talk. We can reconvene in here in a few minutes. Thank you. Your name again?
Oh, yeah. So,
Ma'am, your name?
Summer Greyhouse.
Elizabeth Foster, Your Honor.
Mr. Hunt? Your name again, Mr. Hunt?
James Hunt.
All right. What is you want to go for the test or what?
yeah, can I ask Mr. Hunt just one question?
Sure.
Mr. Hunt,
Yes.
do you have knowledge that the device can malfunction one day and function normally the next day? Is that possible?
I have not seen that in my experience, no.
So you're right, we're going to change our.
I don't want her to sit here now.
I'm sorry.
So just so you know, I'm going to make the decision because I'm going to spare her the disgrace of just admitting to me under oath that she has committed perjury. I mean, I will do that if you want. I don't want her to plead guilty now when she just testified under oath that she hadn't consumed anything until she came back and said it was non-alcoholic beverage. So if you're telling me she's not going to go for their test, I'm simply going to make my finding right now. And there's no reason for her to change her plea because honestly, I think it's horrible if I'm going to sit here and have somebody admit that they just committed perjury in front of me. So that's what I'm suggesting to you. If you want a different route, you can do that. I get it, Mr. Longton. But I still think, even though I'm upset that somebody would do such a thing, I still have a function here, and I'm going to do it to the best of my ability, and that would be my advice to your client. But that's not, she need not take advice from me. So if she wants to just say, if you want to tell me, Judge, we don't see a necessity to go for the test at 4, then I will simply make the findings based on what I've heard here, testimony from your client, from Mr. Hunt, and from Ms. Wiles.
That would be correct, Jim.
Okay.
She will not be taken.
Okay, so I'm going to simply, I'll listen to argument if you want. Do you want to argue or you want me to just make my findings here?
You're fine.
The court finds that the machine was properly working, that the defendant consumed alcohol, and that the document, which Ms. Wild signed February 12, 2026, evidences that intent, or evidences the results. And also, I'm going to find you guilty as charged. Now,
And that's the ruling. The court finds the device was working properly, finds she consumed alcohol, finds her guilty. But what follows isn't just punishment, it's philosophy. The judge says she should have been charged with a felony. This is her fourth offense at age 38. He says she needs sobriety, but he cannot help someone who lies about drinking. That's the key. Sobriety court depends on honesty. Without admission, there's no treatment framework. In his view, denial plus deception equals danger.
now you and I are going to have a conversation, young lady. You should have been charged with a felony. You should have been charged with a felony. Now, I don't know why they didn't charge you with a felony. I don't know. I don't care. It's not my business. I just do what they put here in terms of files. Now, in my view, you needed sobriety because I still think we can help you. But if you come in here and you lie to me, there is no way in hell I'm taking you in sobriety court. Excuse my language. I should not have said that word. Ma'am, don't say anything. You should not be saying anything. You are the whopping old age of 8? And this is now your fourth offense, and judges don't like this when you have 4 offenses by the time you're 38. They should have, like I said, charged you with a felony. I'm not being punitive when I do what I'm going to do here, but you're scaring the devil out of me right now, because when you have a judge tell you not to drink, and you've had 3 offenses, and you've had a Soberlink device, and then you come in and you tell him under oath that you didn't drink alcohol and he knows that you're lying, I can't help cure somebody who is not going to admit that they are drinking. I get it, that they have an alcohol problem. I get it. There's a form and an element of denial. But honestly and truly, you are going to live a short life if you don't get off of this stuff. It's your life. It's not mine. I have no choice here but to forfeit your bond.
Now we hit the financial consequences. He forfeits her $5,000 10% bond. That means the $500 posted is gone. Then he raises it to $60,000 10%. She must post $6,000 to get out. That's a massive jump. Bond isn't punishment, it's risk assessment. And the judge is signaling he now sees her as a higher risk, especially after what he perceives as dishonesty under oath. He even admits he made a mistake giving her the lower bond before. That's not emotional. That's recalibration based on new credibility findings.
Bond, I am forfeiting the bond. That means you're losing your $500, and it also means you're going to have to post. And it's a good thing that you guys didn't go for the test just to verify what I was listen to me. What I was 100% sure of, and that is that you had consumed alcohol. I'm forfeiting that bond. I made a mistake when I only gave you a $5,000 bond. Ma'am, I'm going to explain it to you. I gave you a $5,000 10% bond. You know why? Because you told me, as I recall it, you only made about $50,000. Well, that's why I gave $5,000 10%. Because I thought, well, I got to run a Soberlink. She's had 3 priors. Maybe she'll understand that this judge is a little bit serious, but I still cut you a break. And now you go out and you drink again, and you come in here and tell me what I know are lies. 60,000, 10% is the best I'm doing. 60,000, 10%, you're going to have to post $6,000 to secure your release. I have a pretrial date. Make sure any warrant that was entered is canceled. And
If you have me though tomorrow.
I'm sorry, Mr. Longton.
There's no way.
There's no way in heck I'm letting her out. She scares me.
Listen,
Ma'am,
you're on something.
no. I have made my decision. Listen to me. You are not taking this seriously. You are not. Ma'am, You will not hear me change my mind. I don't decide things over a bowl of Cheerios.
That line, classic. He's telling her this wasn't impulsive. He anticipated this hearing. He says he sensed she had been drinking when he saw her previously. Judges rely heavily on instinct built from years of experience. And now he's doubling down. This is mild compared to what could happen if prosecutors upgrade the charge to felony. That's not a threat. That's reality. Repeated offenses escalate.
I knew if we had a hearing today, you were going to at least have this, because I was sure you were drinking. When I talked to you and saw you under oath, you're making your own bed. This is like going to Maui compared to what's going to happen if they turn around and charge you as a felon. I'm telling you, I'm not arguing with you. They'll let you make a couple of calls. I'll move the pretrial.
Let's step back. Multiple positive Soberlink readings over several days. Expert testimony saying elimination patterns match drinking. No documented device malfunction. Defendant denies drinking under oath. Judge finds testimony not credible. Result: guilty finding. Bond forfeited. Bond increased to $60,000, 10%. Sobriety court off the table. This case wasn't decided on one reading. It was decided on patterns, credibility, and courtroom behavior. So what do you think? Was this solid scientific evidence? Or should the court have demanded a manufacturer report before ruling? Drop your thoughts below. And if you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.